all the details about my profile and all that. Many, I think, events I have forgotten also. You have reminded me today.
I don't know.
So session 1 today, it is law of marriage. You have got this? All of you have given? Law of marriage with special reference to notification. This dated into 3rd January 1963. Rules to provide for registration and solemnization of a form of marriage in Sikkim. I hope all of you know what the term marriage means. You have your own concept of marriage is or no? Huh? Some of you must have faced the marriage also. Is that so? No. So I think it is not necessary to go into much detail of what the term, marriage means. Can you tell me in your own concept what is law? What does law mean? In your own concept. Or difficult to express, no? Concept is there in your mind, but it is not very easy to give expression to it. So I will take you through some of the definitions, or rather say we can say meaning. We had a program debate on the topic was, it was in the university, Sikkim University. The topic was institution of marriage has lost its appeal. That was a long time back in 1913. I was in the guest faculty there. At that time we had, had this program. So I had collected some materials at that time. So this I would like to share with you so that you get some idea. This is what I had. First thing is about, it is one of the universal social institutions closely connected with the institution of family. Correct? You got some idea now? Social institution, universal social institution, closely connected to the institution of family. So, family and marriage are complementary to each other. All of you have families, I suppose. It is connected with marriage. So, marriage and family are closely connected with each other, and socially sanctioned relation between the husband and wife. So some of the characteristics that I had noted was, universally among Hindus, marriage is a sacrament. That all of you know. Hindu law you have read. It's treated as a sacrament, which is regarded as more or less obligatory. I had also come across the system in Japan. In Japan, what they say is celibacy is publicly condemned. If one doesn't marry, then you will have no value in society, I suppose. That is in Japan. Now, in Korea also they say the married individuals are called half partners or what? Half persons. Married individuals are called half persons. As long as one does not marry, he remains a half person, not complete. So that is in Korea. Now, in the Hindu system also, we say Ardhangini. What does it mean? Yes? Better half.
Ardha means half, Angani means half of the
Half
each
part,
other.
half of the part. So better half it is said. But what is said is whether she is better half or worse half, only the other part knows. For the purpose of saying this, it is better half. So Ardhangini in Hindu system also, it means it's half. So as long as one doesn't marry, he remains half. I don't know how many of you are half here or are all full. Huh? According to here, I have recorded this Chinese, he was Chinese philosopher, Confucius. He has said, an individual who remains unmarried commits great sin. So this social, social concepts, social system, this is what concept in the religion we have. So even there in Chinese also they say, if you are still unmarried, you are committing great sin. I think not pardonable. So it's a marriage is a relation between man and woman. All these things are in your mind already, but I'm just telling you so that it gives clarity to your concept. Now, another thing that I noted is marriage bond is enduring, long-lasting between husband and wife. Hindu belief is it's a sacred bond between husband and wife, which even death cannot break. It's a bond. Once it is established, it is forever. Even after death, it continues. Even death doesn't sever it, doesn't break it. This is a concept. Now, what other requirement is marriage requires social approval. Unless there is social approval, marriage will have no, I think, recognition or value. And marriage is also associated with some civil or religious ceremonies. What are those ceremonies? All of you know, I think.
Saptapadi.
In the Hindus, Saptapadi. If Saptapadi is not taken, then marriage is incomplete. This is the Hindu rites. And I think we have in the next customary systems, customary rituals also. There also, even though these 7 steps requirement is not there, other requirements are there. So they have to be performed. So this is social approval is given only if those rituals are performed. Simply declaring I have married her, I am her husband, that will not do. No, society requires certain rituals to be performed, certain rites to be observed, and those are to be done. So civil and religious ceremonies like, as you said, Saptapadi, and different customs have their own rituals. So marriage creates mutual obligation. What is the obligation? Or even after the marriage one should feel free and all, free of no responsibility, free from all responsibilities. Is that so? Certain rights and duties on both husband and wife. Alright? Both are required to support each other. All right? And each other and their children. This is, I think, this is clear to you in your mind. Okay. So, what are the functions of marriage? It leads to establishment of family. One of the basic important functions. Why do you marry? You marry for the purpose of establishing a family. Correct? Marriage insists on the couple to establish a family and procreation. Procreation is also another requirement. And also it provides economic cooperation also. It makes division of labor. Husband you will do some his job, wife will also have to perform some duties. So partners of marriage distribute and divide work among themselves. That is done, I think, it's practical experience of it. If you are not married, you may have noticed among the married couple how duties are performed, distributed. So, I once said social solidarity, unity. So that is marriage. I think with this concept of marriage, I think clear to you. I don't say that you had no idea and concept of yourself, but legally speaking, according to the rites, rituals, according to the beliefs, according to different religions, certain concepts are developed, and this is what I have just shared with you. And I hope it has given you some idea. You can now tell me what marriage is, what are the different duties of husband and wife once they are married. So all those things is marriage. Now, our topic is, what is that? Marriage, law of marriage. Alright? We'll come to law of marriage now. Now, in law of marriage in Sikkim, you must all be aware, we do not have any, compiled or, enacted rules and provisions. It started much later, we are coming to that. But before that, I think, I do not know whether you are aware of these 16 laws. 16 laws. in Gazetted of Sikkim, 1894. Some of you must have gone through it. That is the first book, Gazette compilation, which contains some written rules in the written form. Gazetted of Sikkim, it is called, 1894. Just history is, we are talking about laws. How laws are framed? You can tell us how laws are framed? Yes, in what way?
Either by through the intent of the legislature, through the act of legislature, or through customary.
Customary law, yes, is one way of making laws in the earlier times, more when the society was primitive, at that time. But modern method is passing through the either parliament or that you are very much aware. I know you know about it. But the laws before this enactment in the assembly started. Assembly was established, has been established since the year 1975. What was the position prior to that?
King,
Huh? Only
the king.
king was there. King was the monarch, magistrate, and the high priest. That is the concept. King is everything. That was the concept at that time. So, king's words were laws. So what it is said is, just one sentence I'll just read from there. This is from Gazette of Sikkim, 16 laws. This deals with number of other items also, but we'll confine only to marriage. Now it says, Sikkim laws are founded on those spoken by Raja Melongdong. Laws based on those spoken by Raja Melongdong, who lived in India before the time of Buddha. How long before? How many years before? Now Buddha, 1914 BC. This Raja is mentioned in Kagyu in the 31st chapter. 914 BC means total how many years? 1924 plus 9, more than nearly about 4,000 years. It's a matter of about 4,000 years. So at that time, law was the words of king. This is much before even the present, our monarchy started. It started only in 1642. But before that also. At that time probably Sikkim had not come into existence. It's at that period. So this has been again rewritten, it has been mentioned here. They were again written by Kunga Gyal Chen of Sakya Pa, who was born in 1182. They were again written. First spoken by Raja Melongdong, then again these laws were again written by Desi Sangre Gyatso, who was born in 1653. So I think it was written by earlier by Melongdong and then again modified most probably, amended or some additions like that. It was done later on. So it deals with number of items. First is about war, how to fight war. This was very tough. This is not necessary now, I think. Or you want to go for war and then follow these rules. Then for those who are being defeated and cannot fight, these kind of rules are there. Offences and government servants, law of evidence was also there, but not in the form in which we have been reading. It's not in that form. Now, grave offences, part of it we have, I don't know how many of you have visited our High Court Museum. We have given even the photograph there of the old laws, So we have some idea about that. So we'll come only to marriage. Marriage customs of the Sikkimis. This is what is compiled here. I think this is the first one. We don't have any other written form. So it says, I'll just read out so that you will get some idea what matters it deals with. So first it says, if the eldest brother takes a wife, she is common to all his brothers. Polygamy? What is it called? Polygamy. It is prevalent in many tribal communities. Now, if the second brother takes a wife, she is common to all the brothers younger than himself. This was the system. The eldest brother is not allowed to cohabit with the wives of the younger brother. That was the rule, Should there be children, in the first case, the children are named after the eldest brother, whom they call father. 3 brothers can marry 3 sisters. And all the wives be in common. But this case is not very often seen. Even at that time, I think, this has discontinued. All these have discontinued. Now, then two men not related can have one wife in common, but this arrangement is unusual. That system was also there, but that has also come to be, rejected most probably. A man occasionally, this is another one, a man occasionally lends his wife to a friend, but the custom is not general and uncommon. At that time, you are getting an idea of what the marriage was. About 3000 years, 2005 years to 3000 to 3500 years ago, this was the system. Many of us are not aware of this. The marriage ceremony consists almost entirely in feasting ceremony, only feasting, which takes place after the usual presents have been given to the girl's relations. The only religious ceremony is performed by the village headman, who offers a bowl of marwa to the gods. What is marwa? I don't know. Some kind of drink, I think. Huh? We can drink or something, marwa. Bowl of marwa to the gods and presenting a cup of the same marwa to the bride and bridegroom. They also do afford, they will also have to take that marwa. One of the ceremonies, at that time. It is almost like Saptapadi. You have to do this, unless you have not done this, again marriage will be incomplete. And presenting a cup of the same to the bride. Lamas take no part in the ceremony at that time. No ceremony. The marriage tie is very slight and can be dissolved at any time by either the man or the woman. Divorce was so common, and I think most probably very rampant also. This is about this. And a man may marry his mother's brother's daughter, but he can marry none of his other first cousins till the second marriage. Their system of relationship is peculiar and interesting and is given below. So, next custom we are talking about, at that time we will come to the details later on. Now, regarding succession, it was also a rule. The following order seems to be generally, though not always used: son, grandson, etc. through the males, brother by same mother, father's brother's son, sister's son, mother's brother's son, sisters by choice. If only distant relatives, they only receive a portion of the, or portion going to be to the lamas and the remainder to government. If no relatives, funeral expenses, etc. to the lamas and remainder to government. So this was the system, and probably at that time it has been, brought into written form collection. So this is the as far as I am concerned, I am not able to trace any other written documents which talks about marriage. And this was also done only, I think, in 1894. So this gives us what was the position before, I think, even Sikkim came into existence. At that time, this was the system. But 1894, though, I think 1642, monarchy was established. So yes, monarchy had been established. At that time, also these were the rules which are being followed. These were the, you can say, custom practices which were being followed at that time. So is it clear? Or does it need a repetition? No. So we have talked about a rule or custom in the written form, which is there in the Gazette of Sikkim. Now there was the laws we'll talk about now. The first law that was extended to Sikkim was in 1931. the Indian Christian Marriage Act 1872 of British India, at that time British India, was made applicable to Christian subjects of His Highness with retrospective effect. So enacted law in the form, this was the first one, Indian Christianity Marriage Act 1872. First one. Date of notification was 28 January 1931. This is the first law. Just one thing I would like to know, details will not go. First, one thing I would like to tell you is, this contains no provision for divorce. Just keep that in mind. And then, this was extended when, did you note down? 1931. 1931. It was extended. And then the next one was this one, rules to provide for registration and solemnization of form of marriage in Sikkim. This was notified, promulgated in 1963. 3rd January 1963. This is almost a complete code of marriage. We'll come to that. This is the first time this rule was promulgated, which regulated the performance of marriage, and so many other things like any marriage covers. What are the other subjects? Divorce it covers, no? Yes. Judicial separation it covers. It covers. All those items are there in this. Almost in detail it has been given, but it is not called Act. What is it called?
Rules.
Rules. Why? Maybe it is not called Act because it has not been passed by Parliament, by Assembly, something like that. Because there was no legislative assembly in Sikkim at that time. You are aware of that? When was the first legislative assembly was established in Sikkim? Yes?
74.
No, I'm not talking about legislative assembly here, but law framing body. I have quoted that. That was rules provide for what is that? 1953. In 1953, tell me what was that? There was a body established where law was passed. What is that? Even I had forgotten, looks like. Remind me, if you know. What was that? In 1953 it was passed. We'll come to that a little later. So keep that in mind. In 1953 that law was passed, and the laws that were passed, that was in the previous High Court building. And now, what is it? It is now, what office has come up there? No. Earlier, what is assembly? First assembly. Sikkim. Next to that, there's a building. Some office has come up there. It was at that time. Anyway, this we are talking about this 1963 rule. It is called rule, not act, because at that time you'll notice that in Sikkim many legislations were not called acts. They were called what? Proclamations. They were called what? Notifications. Then they were called what? Rules and orders. But not acts. That council's name, what is the legislative council was established in 53.
Worship
But-
State Council,
State council. When was it established? Tell me.
1953, as a precursor to the legislative.
As
A precursor to the Legislative Assembly by the Maharaja of Sikkim.
1953 it was established for the first time. Then formal system of law making probably started at that time. But even after that also many rules, they are not called acts, only those which are passed in the council, were called acts. So no confusion about rules, regulations, orders, proclamation, because they were used as a common term to refer to all kind of legislations, rules. So 63, Maharaja of Sikkim promulgated what? Rules to provide for registration, and solemnization of the form of marriage in Sikkim, 1963. That was promulgated on, find out the date. That was promulgated on 3rd January 1963. So a formal law, in the form of modern legislation that came into existence with the promulgation of these rules. This was promulgated by the king. These number of issues which marriage laws cover, this has covered, like this provides for conditions relating to solemnization of marriage, what ceremony is required, registration also it provides for. Then it also deals with other issues like, as you say, restitution of conjugal rights, judicial separation, divorce and procedure, valid and void and voidable marriage, legitimacy of children, court to which petition should be made. All those details, procedure has also been laid out. Where the petition is to be filed, how is the authority to deal with that. So in one sense you can say this is a complete code with regard to marriage laws. If you go through this and Special Marriage Act, we'll come to that also, Indian Special Marriage Act, you will find that much of the provisions have been borrowed from there. So it is much modern in its implication. Now, after that, what is the next one? Third is, in 1989, the Hindu Marriage Act 1955 was extended and enforced. That was in 1989. 63 that continued, and then Hindu Marriage Act 1955 was extended. This is with effect from 1/5/1989. Hindu Marriage Act 1955, all of you have read Hindu Marriage Act. There is nothing that needs to be, I think, told to you. And this act applies to whom? Hindus, Buddhists, Jains, Sikhs, or is there? Not only to residents of Sikkim. So the act would not apply to members of the scheduled tribe. That is subgroup 2, I think, no? So that was the third one. So the next to that The next legislation or next rule is, Hindu Marriage Registration Rules 1991. Next to that, Hindu Marriage Registration Rules 1991. This is mainly for the purpose of facilitating proof of Hindu marriage registration. Hindu Marriage Registration Rules 1961. It is there. Hindu Marriage Rules 1961. Provide for registration of conditions relating to. This is 1963. This is 91. This is 1989. Then 91. These materials were given to me by the office. I don't know if you have also been supplied or not. If not, you will have to collect. No, you will have to collect these rules and go through. Then only you will get full idea. Now this says these rules may be called the Hindu Marriage Registration Rules 1991. And it says Act means Hindu Marriage Act 1955. In some way, here the rule fits in. The main act is 1955 Hindu Marriage Act. And the rules, this is Hindu Marriage Registration Rules. This is a rule framed under Hindu Marriage Act 1955. So it provides for registration of marriage, then maintenance of register, filing of application, registrar, who is the registrar, what fees will have to be paid, and power of registrars. All these have been mentioned in these rules. How application and format is also there. So, what are you not reading here? It has been given, this one? Not given, no? Oh, then, because I think these kind of issues will come before you. If marriage is disputed, registration, no? There has to be a certificate of registration, which has been, tested under these rules. So for that purpose, you will have to read. I think you should apprise yourself of the contents of these registration rules. Does it go to all district judges or only family courts it goes? No? Family courts. But in some, I think in some matters, like marriage, execution of marriage may also will come into question. One may say, we are not married. The other say no. So in that case, all these rules will be, I think you should be aware of that. As district judge it comes, I think. What is that? The end of my case?
In Gangtok, special division one handles and family court cases, otherwise not.
No.
Separate.
No. Family court deals with all the matters, but then even other issues, say sometimes in I think family property dispute also it may come. She is not married wife, or may say the son who is claiming inheritance is not born out of valid marriage. So in those cases, this will be one of the necessary documents which will prove the fact of marriage. So for that reason, I think all of you should be aware of it, of this act, of this rule. Registration now, marriage and now registration has also rules have also been provided. So after marriage is performed, what is the next step necessary to show the proof of marriage is registration. So that is notification of 1991 registration rules. Well, I think I have come across some observation where this registration has been done wrongly, no?
Yes.
In Sikkim,
In Sikkim only on the legal marriage.
it has been done, but wrongly it has been recorded. Certificates must probably have been issued.
Yes.
Ah.
Yes.
So if that certificate is issued and if it is produced before you, what effect will you give it to it? Will it be effective? Will it be valid? Ah. So what should they do? One who has obtained a certificate which is not valid under the law, what significance it has? No meaning at all. So, the fault is not that of the person, but then of the authorities. That's what I have read, no? Not per person, then just registered. Huh? There is a
We are facing problems in mutual divorce also because of this issue.
mutual divorce also.
Yes, on the Hindu Marriage Act. Because people who are married under the same community, let's say from a tribal community, they also come to the court asking for marriage, divorce, but under the Hindu Marriage Act they cannot do divorce. So that is also a problem.
So then this issue comes.
For people from different communities, we can tell them to register their marriage under Special Marriage Act and then but then for this persons from the same community, it's a problem.
So what is the relief that will be available to a person who has wrongly obtained or who has been wrongly issued a certificate? What to hear?
It's a big grey area right now because we're actually urging the councils who are coming with these cases to approach the Honorable High Court for some kind of intervention, but nobody wants to tell the cat.
No. What is wrongly issued, which is not valid? For the person who holds that certificate, it is meaningless. There will be no meaning. So, I think the first initiative should be initiated by the very person who is affected by the wrongly issued certificate. He may say it's issued, but it's not correct. So he may apply for proper registration. There is no need to go to High Court for that. Is it necessary? Yes? Okay.
They can go to the authority and surrender that.
Yes. See, what you have issued is not correct. So please issue me a correct one under the correct provision. Then of course if it is not issued, then you can go to higher authority. I have note somewhere that needs to be corrected and all that. I think that is the way out. You will have to suggest that. If it's produced before you and you cannot give any meaning to it because it is wrongly recorded, wrongly issued, then suggestion you can make.
Another issue with regard to divorce also.
But they will not be
Under
talking
custody
to
laws.
us.
They will not be?
Talking to
No, I am talking about obtaining a valid certificate from other authority. Certificate. For that there is no need to talk between the two. You will not have to take the approval of the wife or husband to obtain that certificate. You will approach certificate, you will
Court can declare it, they can ask for the declaration from the court for making that certificate which has already been issued as null and void.
No, that can also be done, but there is no need to declare in that way because there is a relief available to the concerned individual. He can approach and obtain a valid certificate. So why should there be declaration for that? In the declaration you will have to say all the certificates issued by so and so are hereby declared that is valid. That is not necessary. And that doesn't solve all the problem. That doesn't give him a certificate which is valid. And even if you declare, the only way out for the person who is affected by that wrong issue of certificate will have to approach the appropriate authority He can say this was issued, wrongly issued, so it has no effect, so issue me a valid one. And he can obtain that, he can produce it at the court. For this, I do not think any kind of writ would lie, or even a declaration suit is required. Am I clear? I don't think you should suggest that you should file a suit for declaration. Rather, you suggest them, you tell them you go to the competent authority and produce a press one. Then they will have to produce. If they don't produce, then that's different thing. And for that, as you said, approval of the other side is not required. You don't have to approach your partner. I'm approaching for this certificate. Please consent. It is not necessary. Oh, in marriage certificate? No, in registration. I'm talking about the certificate of what certificate we are talking about?
Marriage certificate.
Marriage certificate. Marriage certificate. The other side, yes. In that case, where certificate marriage has been performed, no. Registration, of course, one will have to whatever is necessary to prove that he will have to produce. He may have to, I think, show that there was ceremony and there was this. All those things they may have to prove. There are, I think, it's always there in the rules. Apart from, I think even consent may not be necessary, but you have to produce all those materials. And even if the consent is given, but if those materials you cannot produce them again, that's not sufficient. Clear? Correct? Or not correct? Huh? Tell us, we can again sort it out. Yes. You have noted which one you have noted? 19? Hindu Marriage Registration Rules 1991. This was for the purpose of facilitating the proof of marriage for registration. Earlier in the customary law, probably there is no question of registration. Will be there to register at that time. Probably they did not have register also. Writing them around. There was a time. That was the time in our society, you know. So we are dealing with matters which are prevalent at that time also in the customary law. That was the fourth, Hindu Marriage Registration Sikkim Rules 1991. Now, come to another one, the fifth one. It is notification number 10 LR dated 9/8/2007, just recently, I think. After, many of you must have joined service then. 2007? You have not joined? Oh. Huh? At 2007? Anyway. That can be no ground to say that I don't understand what we produced. So, is it given here? 2007. So, this is notification number 10 LR dated 9/8/2007. This was published on 28/2007. You got it? Oh, I think this is correct.
10 LR dated 9/8/2007.
To keep an account of that. You have seen it? What does it say? Please read from there. How can you read? Mr. Jagat, you have a louder voice as a please. In exercise of the powers?
Yes. It's in exercise of the power conferred by Rule 34 of the rules provides for
34 of that rule, 63 rule which talk about it.
registration and solemnize of a form of marriage in Sikkim issued by Home Department, Government of Sikkim, notification number 1520, Home Department Act dated 3rd January 1963 is hereby notified that henceforth the marriage of
All.
all who are citizens of India solemnized within the state of Sikkim belonging to
Various
religion shall
be compulsorily registrable
be compulsory registrable with the marriage officer of the respective district in whose jurisdiction such marriage are permitted.
So clear? It has become compulsorily registrable. About who are citizens of India, henceforth marriages of all who are citizens of India solemnized within the state of Sikkim belonging to various religion, not confined to one religion, various religion shall be compulsorily registrable. So now registration is compulsory. Earlier it was optional maybe and all that. And of course it's a sad thing that even when they approached, they were issued wrong certificates. It is not their fault. Anyway, so whenever there is an issue relating to validity of marriage, then one of the documents to prove the validity of the marriage, performance of the marriage is certificate of marriage, which is compulsorily registrable now. So these 5, I think I have been able to trace out the state of Sikkim belonging to. Now, Special Marriage Act 1954 extended on 9/10/18. Now, next law that has been extended is, please note down, the next one is Special Marriage Act 1954. This is extended on 9/10/19. Just see Special Marriage Act 1954. I have brought that here. The Special Marriage Act 1954. We are used to only printed form of rules, no books, not like this. So, but your generation is different. That is sufficient for you, no? So this act 1954, this was extended. Did you note down? Extended when? 19 has been enforced with effect from? No, this is extended but enforced with effect from 54/21.
Also was law secretary.
Also, yes.
So this was Judicial was the law secretary. Right?
Yes.
Sorry, Lordship, I shifted it back because of the AC. I was just saying that Judicial was the law secretary then. When this Special Marriage Act became enforceable in Sikkim.
So many times the Minister of Home Department and Minister of Law and Justice with the package of TV.
Then why is he keeping so silent when we are talking about legislation on that?
Actually, there is a two act yet to be enforced in this state.
What's that?
Indian Divorce Act,
Huh?
Indian Divorce Act 1889, and Christian marriage. In Christian divorce.
Christian Divorce Act.
Divorce Act.
Hmm.
It is pending
That Christian Marriage Act did not contain a provision of divorce. God forbid. But Special Marriage Act 1954, I think it has a provision for divorce. It applies to everybody. Huh?
Yes, sir.
Let's see, divorce. Marriage of such conditions, then notice intended marriage,
Lordship, can I just interject with one thing?
Just a minute, I'm just hanging on. Just a minute. Procedures, please, registration, appeals, then judicial separation, voidable marriage. Divorce is there, section 27. It provides for divorce. Section 27, which says, 27, which says, 27, subject to so and so, so and so, so and so, petition for divorce may be presented to the district court either by the husband or the wife on the ground that the respondent has, after some marriage, has voluntary, that this or this has deserted on these grounds. So, that provision is there in the Special Marriage Act. And that covers this Christian Marriage Act, marriage under that also. Yes? You are saying something?
Your Lordship, this was with respect to the registration only.
Registration of marriage.
Yes,
Yes.
Lordship. Although the law was there, but the compulsory registration was not enforced. So in 2006, there was a judgment of the Hon'ble Supreme Court of India in Srimati Seema versus Ashwini,
Yes.
where marriage registration became compulsory, setting up of marriage officers, registrars became compulsory. So even in Sikkim, that was like an after effect of what?
No, that law was brought in compliance with the direction of the Supreme Court.
Yes, Lordship.
Have you noted that?
Yes, Lordship.
Since there was a direction of the Supreme Court, because there was a, I think, case you have mentioned.
Seema versus Ashwini,
Uh,
2016.
Their women commission made a submission that since marriages are not compulsorily registrable, number of disputes related to marriage, like one will come and say, you are not married, you are not my wife, that kind of thing. So injustice to women.
Especially in those marriages which have taken place.
In those marriages which are
not in the Special Marriage Act, but especially under the Hindu Marriage Act, where
other cases
yes.
where registration is compulsory, then these issues came, and I think it was a gender equality related issue also. No, there was inequality because the husband could always, I think, say reject, no proof of marriage. So Supreme Court in that case has directed that all the
marriages.
that direction is here. That direction to Supreme Court in that case was, it was just by Justice. 20. Paragraph 17 says, accordingly, we are of the view that marriages of all persons who are citizens of India belonging to various religions should be made compulsorily registrable in their respective states where the marriage is solemnized. This was the direction. And accordingly, the direction was, we direct the states and the central government to take the following steps. One was, the procedure for registration should be notified by respective states within 3 months. All these directions are there. So it was in compliance with this that law was passed. Marriage Act 1954, that was extended, and then Indian Civil Marriage Act may observe any ceremony and so on like that. Yes. So now what is the position now?
It's compulsory registration.
Register. Some of the gaps, some of the loopholes which were left under the earlier laws and the customary rules also, alright, those things have been blocked now. Now with the enforcement of these acts, now Sikkim has also brought that compulsory registrable notification. When was it issued? You were there in the law department then? You issued it up.
Extended, then I subsequently notification.
No, this notification issue I'm talking about.
Notification that I have.
Oh, you're not.
Only things that I have.
But you were aware of the background.
Yes, I do.
So this is the position with marriage law. As we said, the first is the law marriage we have talked about. Rules to provide for registration and solemnization of form of marriage in Sikkim. That was in 63. Now, subsequent to this, there are a number of other rules, notifications, orders which have plugged the loopholes in the previous acts and then made registration of marriage compulsory. So to that extent, I hope the marriage law is clear to you. Any questions you would like to raise?
We still have a little bit of doubt with regard to the meaning of special marriage. What actually constitutes special marriage? Is it marriage between parties who are from a different religion or community, or all citizens of India? Because it says about two Indians also, and then between Indian or foreigner also, and foreigners also.
See, the Act provides for special form of marriage. Not Hindu, not Muslim, not Christian, but special. Special form of marriage which can be availed of by any person in India and all Indian nationals in foreign countries, even if they are in foreign countries, irrespective of their faith, which either party may profess. Irrespective of
Hindu can register my marriage under special marriage act also.
Not if you are getting married to a Hindu.
Hindu Marriage Act, is there a provision in Hindu Marriage Act for registration?
After 2006?
Hmm.
No.
But if you exercise an option to register under this, there is no bar, it says.
Worship section 21.
I'm 1 minute going. The party may observe any ceremony for solemnization of marriage. Maybe Hindu, maybe this and all that. Registration of marriage, persons who are already married under other form of marriage.
When it was promoted,
This will give you the this will answer that question. Persons who are already married under other forms of marriage, yes, may register their marriage under this act. Clear?
Lordship,
She was asking if she is married under the Hindu law, Hindu Marriage Act, whether she can register. The provision here it says, persons who are already married under other forms of marriage may register their marriage under this act.
Lordship, this was actually promulgated in those times to accommodate.
Yes, yes.
So, Lordship, this was promulgated to accommodate those kind of marriages. Sometimes, like in those times, Arya Samaji marriages, Brahmo Samaj marriages, all those kinds of things were there, where they did not exactly follow the rituals of Hindu marriage, but more of like the westernized version of, or the reformed, so-called the reformatory movement, After those, the marriages which are taking place under those kind of structure, this act was like promulgated, Lordship, but now I believe it is generally used for registration of those marriages between interfaith couples.
That's what it says.
Yes, Lordship.
I think it wants to, cover those cases which fall outside the other acts, as you say, for some reason. I think that's why it's called Special Marriage Act. Now, on and from 15/4/2001, 2021. Now you cannot say you are students, you are already, I think, officers. 2021? So on and from 15/4/2021, any person can solemnize their marriage under this act. Any person under this act. So Indian Evidence Act, anyway. Now, I think, I don't know whether these issues have come any before any one of you. How is a marriage proved? If somebody disputes, and if somebody claims that there is a marriage, what is the way to prove it? We talked about certificate and all that. There is a provision in Indian Evidence Act. Have you dealt with that provision? No? Any issue has arisen before you? Position and law in Sikkim. I have noted that, I suppose. Okay. Before and followed in Sikkim, then Indian Evidence Act. Now, this is Special Marriage Act, this is Hindu law. I have studied one, but it's not there. I have brought an old one. Yes. Any question before you as a district judge or family court judge, or say in this case even as civil judge? Has it arisen? Have you dealt with that question, Mr.? No. What about Mrs. Agar? What about you all?
Lordship, I have dealt with one COI issue where the question of legitimacy of the child, or not in fact the legitimacy, but the legitimacy of the marriage was in question. So the argument was that not the legitimacy of the marriage also, Lordship, the legitimacy of the child being born through that marriage. So the presumption is that if there is a child born when two people are cohabiting with each other, then the presumption is that that child has been born through that marriage. If there is an infant who was born during the subsistence of that marriage, then the presumption is that that child is the legitimate children of those two people. That much I've dealt with.
No, that's a different issue. I think the customary law we may deal with that. My question was slightly different. See, there's a specific way of proving a marriage, that has been provided in the Indian Evidence Act. Now, you have a different name. I think, what is the name of the Evidence Act? Okay. Bharatiya Saksha Adhiniyam. So we have to update our knowledge. These are new terms, new names. It will take time for us to, I think, even properly pronounce it. So I'll just tell you the previous provision only, all right? You can just see that. Now this is, first is section 13. Whenever there is a question of, have we exceeded our time or time? Huh? Time, this is still 10 minutes. I think we'll finish it in 10 minutes. Yes. I think all of you do not seem to have dealt with this. This is note down, section 13 of the Indian Evidence Act. In that new act, it is 26. Section 13. I'll just read and it will give you an idea. See, the heading is facts relevant when right or custom is in question. Right or custom is in question. This is about relevancy of facts. So where the question is as to the existence of any right or custom, the following facts relevant: any transaction by which the right or custom in question was created, particular instances in which right or custom was claimed, recognized or exercised. This is custom also. That is 13. The next section is 32, subsection 4. 32.4. 32 to you know? Statement by persons who are dead. In some cases, even statement of persons who are dead is also relevant. Now here, section 32, cases in which statement of relevant fact by person who is dead or cannot be found or is relevant. This you have read, 32. Now, we are concerned with subsection 4. That says, are themselves relevant facts in the following cases, where the statement is or gives opinion as to public right or custom or matters or general interest. Now custom, marriage also, if it is there, then also this question will come. When the statement gives the opinion of any person as to the existence of any public right or custom or matter of public or general interest, of the existence of which, if it existed, he would have been likely to be aware, and when such statement was made before any controversy as to such right, customs or matter had arisen, it is also relevant. Otherwise, opinion is not relevant. Alright? Opinion, you may have a very good opinion, but then that will have no relevance. But in these cases, if it relates to what? Opinion as to public right, custom and all that, opinion also. Now the other is section 35. Now here, section 35 speaks about relevancy of entry in public record made in performance of a duty. Like that certificate, issue of certificate and all that, the register will be maintained. If it is there, that will also be relevant. And then the last one is 48, 43, 45, 48, 48. Opinion as to existence of right or custom when relevant. So when a question arises whether a particular custom existed in a particular society, then what is the way of proof? Because you will not have in enacted form, nothing in writing relating to those times when even writing probably was not discovered at that time. What is the way of proving it? So in that case, opinion as to existence of right or custom when relevant. Then also we say, when a court has to form an opinion as to the existence of any general custom or right, the opinion as to the existence of such custom or right of persons who would be likely to know of its existence if it existed are relevant. Not binding, but they will be relevant, which a court can take into consideration. While coming to the conclusion, this is the opinion given by so-and-so. Because even in my time, I think question of marriage, I do not remember. It was not raised in any matter. But then there was one matter in the High Court way back in 76 or 77. The High Court had examined all these persons, old persons, to find out, to have their opinion, to have the information regarding the existence of that marriage. So on the basis of those opinions recorded by High Court, the matter was disposed of. I don't remember the name of the case, but if you can come across any case like that of the High Court, you can. That is judgment of, I think, A.M. Bhattacharya. So now today's subject is only rules to provide for registration and solemnization of form of marriage in Sikkim. As I told you, This is a complete code, and it provides all the issues which are covered by a marriage law. So Special Marriage Act, this Special Marriage Act, if you compare them, more or less 99% they are common. Maybe it was borrowed from this. The only fact is that it has been called the rules, not the act. So presently the rules to provide for registration and solemnization of a marriage in Sikkim is in force or not in force? That compulsory notification is also there. So a marriage solemnized, and that says in Sikkim or something, just I read out that notification, marriage will be compulsorily registrable. What is the purpose? The purpose is to facilitate the proof of a marriage. And as that case which she quoted, what is that case? Sima versus. So in that case, as I told you, the issue that was raised was because of the unclarity, lack of clarity about registration of marriages in all these acts prevalent in India. The submission was that is causing great inconvenience, great injustice to the women. So the Supreme Court, considering all those issues, then came to the conclusion that a registration of certificate of marriage will be very much necessary to do justice. Because if certificate is not there, even one has seen it, they have married, and all that, but then one cannot say, just cannot say, I have seen them, I have attended their marriage, can you just say that? Huh?
But there is no awareness among the public of compulsory.
It is like this. For that, law is not to be blamed. Law after enactment, I think one of the duties of the concerned authorities is to bring awareness about them. Some programs, awareness programs. SLS is doing that, I think, Legal Service Authority. I think even these new laws, I think some programs were here, no? So, but if they had just, stayed on, just law has been passed by Parliament, what is there for us to do? Let the persons who are interested do. Will that solve the purpose of law? So law needs to be understood by the beneficiaries for whom the law is made, and also the beneficiaries should be aware and also capable of claiming the right given under the Act. Such law is there, we have that is not sufficient. India, it is said, India is a country which lacks no law. That's what we are told long time back. Our country, there is no lack of laws. Laws are there, but then in the implementation, laws are not implemented. In many cases, if you ask me, what are the different rules, regulations passed in India, in Sikkim, I will not be able to tell you what are those. It is there in these I think, different laws. No, in the law department has compiled that, old laws. How many notification rules altogether? I find there are 4 volumes. 4th volume is also come. How many? So after legislation, to make the law effective, to achieve the object for which the law has been made, the next step is to bring awareness. of the public, means awareness of the public for whom the law has been made. Then only that serves the purpose. Constitution of India, you all have read. What is fundamental duties? Fundamental duties. You have heard, I suppose, what is fundamental duty. You have read also. Now, the trend in India, in our place, was only to claim rights. This is my right, that is my right. Under this gives me right, you have to keep, no right. And no performance of duty. One condition is that you should claim your right only after you have performed the duty. Clear? That is what fundamental duties which has been brought in the Constitution 77 or 74? 51 inserted in when? Sometime 74 or 71. No, that was so the concept has now changed. Law alone is not sufficient. Law has to be given effect to it by doing what is necessary to do that, bringing awareness among them. So I can tell you, we were students then. As Mr. Subba had said, I did my law from Shillong Law College, Meghalaya. There was some interesting case in the district court. Those days, district collectors used to hear all cases, criminal cases also, civil cases also. No district, no civil judge. Executive officers used to hear. I don't know how did they used to decide, but that case was interesting, so we used to go. Number of us in group used to go and attend the court, The case was, of course, there was dispute between brothers about some tea estate in Assam. So in that dispute, 3 brothers were shot dead when they were coming to Shillong in a vehicle. And in that case, one, he was also shot, but he was not dead. He acted himself to be dead, as if he was dead. And the blanket. I can't count that. We used to enjoy his statement, They came, and after some time they touched the body and said, how soon they become so cold and stiff. And he was hearing, but he was just acting as if he was dead, because he was also shot. He was to say, one bullet passed through close to my beards and it burned my beards also, beards hair. So that's, we used to laugh hearing that, So in that case, some lawyers from Calcutta had come. So due to the discussion, what they had said was, our constitution does not have any provision regarding duties to be performed. The constitution provides only about rights. So one of them said, this kind of provision exists in Constitution of Nepal. In Nepal Constitution, there is a provision which lays down the duties of the citizens. And after doing that duty, then only they can claim the rights. At that time, that was sometime in 71, I think so. We thought there will be no duty in the Indian Constitution. But then this matter was discussed, and later on, 74, 76, I think, this was fundamental duties. We have no copy of Constitution. So around that time, this was inserted in the Constitution. Now, even the person who claims a right, you have it? Constitution article, duties article 51, A. Let us see when it was brought into force, inserted. Fundamental duties. This was provision as to fundamental duties cannot be enforced by writs. They can be promoted only by constitutional methods. They can be used for interpreting so and so. This is 3. Part 4A containing Article 51A by the Constitution 42nd Amendment. 42nd Amendment Act 1976 with effect from 3/1/1977. So these fundamental duties, Article 51A was inserted in the Constitution of India by the 42nd Amendment with effect from 3rd January 1977. After that we have a provision for duties. So don't think only about rights, also think about duties which you are required to perform. Because this specifically lays down 40 or 51A, it shall be the duty of every citizen of India to abide by the Constitution, to cherish and follow the noble ideals, to uphold and protect the sovereignty, to defend the country, to promote harmony, to value and preserve the rich heritage, to protect and improve the natural environment, then to develop the scientific temper, humanism and the spirit of inquiry, to safeguard public property and to abjure violence, to strive towards excellence. So these are the duties which have been laid down. So we shouldn't say that our laws are useless. Our laws are there, but then nothing is being done. It's not like that. Because as that wrong registration of marriage, is that the fault of the law? Whose fault it is? Huh? Fault of the authority. So for that law is not to be blamed. If authority makes a mistake, there's a provision. What was that? There's a provision I was reading, but no, it doesn't relate to that. Model marriage, registration, interim orders, validity, then accountability. There is a provision in 31, Rule 31 of these rules. I'll read this out. Whether you will find it usual or unusual, I don't know. But let me read out for you. It says, any magistrate, any marriage officer who knowingly or willfully solemnizes a marriage under this act, I think, without publishing a notice regarding such marriage as required by Section 2, and within 30 days of the publication of the notice of such marriage, or in contravention of the other provision contained in this rule, shall be punishable with imprisonment for a term. Please read this. Shall be punishable with imprisonment for a term which may extend to 1 year, or with fine which may extend to 500 rupees, or with both. What do you find? This provision is okay? How do you feel? This is this accountability. This is there even in the Special Marriage Act. If the officer, concerned officer, he has marriage officer, if he doesn't do it as per the rules, then what is his liability? Shall be punishable with simple imprisonment for a term which may extend to 1 year. If it applies to civil judges also or judges also, will you have? If they give a wrong judgment, quote a wrong provision and give a decision, they will be imprisoned for, simple imprisonment for 1 year, or even life imprisonment. So this is, I think, one provision which I could notice in this, and also in the Special Marriage Act. It is brought from the Special Marriage Act. So, when I read this provision, I was thinking of that case where they have issued wrong certificates. Wrong marriage certificates under wrong law. Should they be imprisoned?
Someone to treat,
Huh?
someone to treat as wrongdoing.
So, keep this provision in mind. I do not know whether this is penal provision in these rules. Mr. Jagat, you have dealt with so many laws in law department, and when this was issued, you were there or not? 63. You are a student. So that immunity from law for whatever public duty you perform, judicial duties which you perform, they are immune from liability, criminal liability. If you can show that it has been done in the performance of my duty, then that immunity comes in. But in this there is no immunity. There will be imprisoned. If you bring this to the concerned notice or concerned authority, then the marriage officer will have to be ready for. Who are the marriage officers? Huh? SDM and Mr. Collector. In what? Which one? Where marriage officers? No. Chief Secretary, and then they have been. In what law is that? Registration officer something. Earlier in the earlier law, Chief Secretary, and then there was another name is also there. So, any other fault pending with the system of law that we have been dealing with? Please don't forget about the fundamental duties. Don't impose a liability only on others. So the remaining 10 minutes or more time is over, no? Oh. Interactive section. For that, lecture session. You have, I think, good knowledge about so many laws here and there. So we are only debating on how the laws are to be followed, are to be enforced. Who is to be blamed, who is not to be blamed. Of course, many laws, I think, not only in Sikkim, elsewhere also, in any societies, they are not very suitable, they are more injusticiable. Injustice is caused by those laws. There are some of them I will read out from there. You have heard it. I do not know how many of you have read the 16 laws. Law of evidence, law of imprisonment. This is about imprisonment. This is about murder. This is about bloodshed. Theft. This is for those who are false and avaricious. The following oaths are required. Here, these, in the High Court Museum also we had placed this there. If it is thought a man is not telling the truth, the oath should be administered first. At the time of taking the oath, powerful gods should be invoked, and those who are to administer the oath must be present. It is written in ancient law that bird of paradise should not be killed. The poisonous snake should not be thrown down. The raven should not be stoned, and the small tortoise should not be defiled. Thus, pure lamas and monks should not be stoned. So magicians, shameless persons, women, fools and dumb and children should not be shot. Men should be employed who know both parties and are intelligent and truthful. Those willing to take an oath should be of equal rank. The case should be settled. Here, this talks about a process. Here, when all are present, the case should first be settled, if possible, by arbitration. If this fails, the ordeal either by hot stones or boiling oil is resorted to. What is this? If somebody claims that I am innocent, he will have to dip his hand in the boiling oil. We have given a photograph also that in museum. So, see, the oil must be supplied by government and must be pure. It is boiled in a pan that is 3 inches deep. If in the oil a black stone and white stone are placed of equal size and weight, he who has to take the oath must first wash his hands in water, in milk and in widow's urine. His hand is then bound in a cloth. This is the custom. Interesting, huh? He has to take oath must first, yes. His hand is then bound in the cloth and sealed. This is done a day or two before the ordeal in order to give him a chance of confessing. The vessel with the boiling oil is then placed so that the stone cannot be seen, and he has to take one out. If he takes out the white one without any burn, he wins his case. Is it possible you dip in your boiling oil and then take out your hand without any burn? Without any burn, he wins his case. He who gets the black stone is sure to be burnt and loses his case. Should he who gets the white stone be slightly burnt, it means he has partially spoken the truth and wins half of his case. This was the law at that time. Do you think it is real justice? So we don't say that all laws, of course present is different in those days, all laws were fair and to the benefit of the people. It's not like that. Today is this is last Saturday? No, fourth Saturday? It's working day today? Oh. Then it is a relaxing time for you? Huh? Not being in court. Any issues that crop up in your mind about all these, we can always sort of discuss. Rightly or even wrongly, you are not right, you are wrong. One cannot claim that you will be right all the time. Do you agree to that? All your judgments will not always be right. What we speak of lower court, judgments of the Supreme Court, by the higher bench, they are set aside. So being right is something not a simple issue. So the next session topic is customary laws of Sikkim. With special reference to marriage of tribal community. About custom, partly we have talked about in the first session also. Now the topic is, as I already told you, customary laws of Sikkim first. That is with reference to marriage of tribal community. So, what is custom is also again, nobody is not unaware of it. What is custom? Huh? Can you tell me what is custom?
Age-old practices, actually.
Age-old practices. Age-old practices which has been accepted by the society. Age-old only is not, I think, only criteria.
Continuity.
No. Yes.
Continuity is one of the characteristics.
Continuity is one, yes, number 10. Acceptance by the society and it has to be a very ancient one. What was being done 10 years ago cannot be custom. So, the position is like this. In Sikkim, we had formal government since when? Say monarchy period we had, I think. But prior to that, what was the situation?
Each community had their own chieftains and they were governed by their own customs.
At that time, ancient society. So, someone has said, custom is to society what law is to state. Society also needs law, but that law is not in the form of legislation, but in the form of long practice, accepted by the society. And then only it has gained its force of law. So, wherever there is society, there is law. So with this we have to assume that no doubt there are no written laws in Sikkim prior to monarchy period. Even prior to that, of course 16 laws are, and that deals with some period. Even beyond that, what is the situation? Societies were there. And when there is a society, there has to be a law. There is a maxim, I don't know whether you have read it. Ubi societas ibi jus. What is the meaning? You write down. Ubi societas ibi jus. Where? Right, the meaning. Very correct meaning. Where there is a society, there is a law. So that means when we say that there was ancient society in Sikkim, then we can assume that there used to be laws also. Laws not in the form of legislation, but in the form of customs. So wherever there is society, there is law. So law is a social need and is followed mainly for convenience. That is what is said. So what is the definition of custom? We have talked about custom, that it should be long, it should be practice, all that. That's the definition by Carter. Then it says the simplest definition of custom is that it is uniformity of conduct. It is uniformity of conduct of all persons under like circumstances. These customs bring about uniformity. It doesn't allow each and every other family to follow separate customs and all that. No? In a society, some system is developed, some rule is developed, some practice is developed, and that is followed in the society. If that has been followed for a long time, continuity for a long time, then it takes the form of custom. Another meaning and definition is custom is the rule of conduct which the governed observe spontaneously, even without enforcement, and not in pursuance of law settled by the political superior. In state, there has to be a law passed by legislature, and that is enforced. There has to be enforcement agencies. And in case of custom, there is no enforcement agency. No civil judges or district judges or high court judges at that time. So, Halsey's definition is like this: custom is a particular rule which has existed either actually or presumptively from time immemorial. Like you had been mentioning, it has to be in force, it has to be followed for a very, very long time. I think not only in one generation, for generations. And has obtained the force of law in a particular locality. Like those we did 16 laws, they were practiced for a long time in the society and they became almost law. So there is a definition of Judicial Committee of Privy Council. So it says custom is a rule which in particular family or in a particular district, territory also, has from long usage obtained the force of law. Custom, of course, we don't name it as a law, but then in its function, it performs the role of what we call law at that time. So, how it originated, there is one line I will read out. A study of the ancient law shows that in primitive society, the lives of the people were regulated by customs which developed spontaneously according to circumstances. See, when the same was being done again and again in a particular way, it assumed the form of custom. Not that it is done for 1 month, 1 year or 10 years, that is not a custom. It should have been observed for a very long time. In the same way as we follow legislation. Indian Penal Code, how long we have been following? 1860, more than 100 years. But that's legislation now. So, it is said, a study of the ancient society shows that lawmaking was not the business of the kings. Law of the country was to be found in the customs of the people. Because in a primitive society we had been talking about, there was no, space for king. There were no kings at that time. Monarchy had not developed. So still the laws were developed. So that's why it said, the lawmaking was not the business of the kings. Law of the country was to be found in customs of the people. The people were accustomed to a particular way of living and doing things, and that has to be found in the customs of society. This is what we have just been talking about. Some practice which a society has started, has continued for years together, centuries together, no? Then that has taken the form of what we today call law, custom. So custom is a rule, it is, in one sense it is law. Now later on, position, the same custom was recognized by the sovereign by putting his imprint on it. When the sovereign came, when I think monarchy was established, the monarchy also accepted that this was the law prevalent in society for such a long time. So it is said, recognized by the sovereign by putting his imprint and accepted it. And then thereafter, I think we can call it law. Sovereign has accepted and enforced it. Because in the society, no sovereign. You know what is sovereign, no? But in a society, there is no question of sovereign being present and exercising that power. So it was in this way that the custom was transformed into law. Many of the laws which we follow today were customs in the past centuries. They have been, made a part of the legislation. In the codified list, they have been brought. And so that has become law. King, that's what it said, king also did not like to impose something new, but wanted to stick to something which the society has accepted already. That is how the king recognized the system, the custom, and then it became a law. So, custom thus becomes law when it is embodied in the act. Or legislature. It becomes law when it is enforced by the state. In primitive societies, there is no question of a state which is exercising authorities and which would enforce these laws. It was not there. So that is how the customs became law. As I told you, in a number of, I think, legislations, the provisions, they are based on customs. Even in the Marriage Act also, those marriages were performed from the time the society came into existence. Now those have been incorporated in the Act. Now, how a custom becomes law, let me tell you, you don't have to go to that other centuries or to other countries. In our own state also it has happened. Can you tell me how it has happened? What we have discussed is a custom does not remain custom always. With the passage of time, it takes the form of law when it is recognized by the sovereign. So this is how law develops. Now, this is what I have prepared. I don't think we have published it. I have said, this is judicial history of Sikkim. This history can be studied under 3 heads, I have said. I think partly it is there in the High Court, museums, magazine also. One is pre-monarchy period. Systems prevalent in the society before the monarchy was established. That period, very ancient period. And the second is the monarchy period. After the monarchy, I think all the period has not remained without written laws. Laws have come into existence, like that Gazetted of Sikkim, those laws. In written form, that is the first thing first written form of the customs followed. Others I have not come across. Some research, I think this area is very open for research. So some of you, in your lifetime, you can do that. A wide area is open. So in this pre-monarchy period, I'll just read out, no? I'll share with this, that part, that will give you some idea how custom has developed into law. Alright? During this period, means pre-monarchy period, Sikkim was a habitat of tribal societies. Correct? The societies present at that time was tribal in nature. Now, the social organization in prevalence was tribal in nature. So, it functioned without a state. No state, no chief minister, no governor, no president. So, without a state, without a formal government, no MLAs, no elections, and without any written laws. No written laws are there. But still, I think the society had to manage, had to run. The society used to be headed by a tribal chief. All of you have that idea? Tribal chief. Tribal chief who could be hereditary. Tribal chiefs could be hereditary also. Or elected for life. We'll come to this a little later. Elected for life or for limited period. Such tribal societies were more like city-states in ancient Greece. Greek city-states, you have read? Greek city-states, how it developed in Greece. Small community, they used to know each other. Then all common things concerning the society used to do it. That is how concept of state slowly developed. But then when it is called state, there is the question of chief minister or prime minister would not come. As in ancient Greece, who believed in democracy, not in monarchy. In consensus, not in authority. In society themselves, they would decide what to do, what next, and as per that, they would do. This is the system prevalent in the ancient society prior to establishment of monarchy in our state, in Sikkim. We are talking about Sikkim now. Now, administration of justice during the period was the responsibility of the headman or chieftain. There was no need to go to the court of civil judge or to the court of district judge. To the chieftain one used to go. And what he used to do, practice is, the chieftain used to perform this function with the help of the council of elders. He alone, he would not do it individually on his own. He would say, perform this function with the help of the council of elders, despite, disputes used to be decided in the open before other members of the clan. They gathering in a meeting, like present day panchayats. They would sit, discuss the matter, and they would decide. Used to be, and the decisions so delivered by the council of elders. Council of elders used to be honored by the parties and the societies at large. That's what we say, society used to accept it. They would not challenge, no, it's not yours, you cannot do this. It's not like that. They used to accept it. So, the system prevalent in that society is clear. So, what was the system in Sikkim? See, the system of administrative justice continues and still exists in some areas of North Sikkim. Others, legislation and all that has covered. North Sikkim, particularly in Lacheng and Lachong. Lacheng and Lachong in Chungthang subdivision under this system, subdivision. So what is that system called? You may have some idea. Yes? Jumsa, which used to be headed by chieftain, and with the members, case would be decided. No. So under this system, the dispute is first heard by the people. Which people? Head. Heard by the people, that is the headman, and if he fails in his endeavor to settle the matter amicably, first he will do on his own. If he fails to settle the matter amicably, he forms a body of gambos. What is gambos? I don't know. This is Bhutia word or Lemsa word? I don't know. Gambos? Elders. He forms a body of gambos, it is here. The village elders. Village elders. Village elders, and this body hears the parties. Next, not only the people alone, but with the panchayat sort of thing, parties, and decide the dispute. There being no written laws, what law they follow? There being no written laws, the laws followed in such solution of disputes is the customary law. Clear? This is how a system followed in societies, involved the evolution of customs. And customs which used to provide different, procedures in order for settlement, they used to follow it. Then, after hearing the case, the final judgment is delivered by the people. Any one of you from North Sikkim or from Lepcha community? Nobody? Sure. Alright. Was laws followed in such resolution of dispute is customary law. In present day, what law we follow in resolution of dispute? Procedure you have to follow, criminal, in crime CRPC, in civil CPC, Evidence Act, and the relevant substantive law. But those days, what they used to follow? They used to follow the customary law. After hearing the case, the final judgment is delivered by the people. The guilty is punished. Here, the guilty, criminal, that means. The guilty is punished and some fine is also imposed. They can impose fine also. A part of such fine is given to the aggrieved party, compensation aggrieved party, and the rest is kept in the Jumsa fund. Jumsa is a fund of so many. So this is the system now present in North District. Even at a time when in the rest of the countries, the rest of the part of the state, there are enacted laws. Alright? Now, in olden days here, major crimes like murder also used to be settled in this manner. The murder case is settled by whom now? It goes to which court? Court of Session. Not to Jumsa. But
from what I've noticed, criminal cases, if it's committed by the person from the community, never gets reported to the police station. Only if it's committed by any outsider, then it gets reported to the police station. Otherwise, whatever happens within the community never gets reported.
But no, what is said is criminal, this major acts also say is punished in a part of such fine is imposed to so and so, and the rest is kept in the. In olden days, major crimes like murder also used to be settled in this manner. That means now it is not being settled. I will tell you one incident. Like Mr. Dishit, I joined bar in Nagaland, no, at that time. Nagaland is a state which has 16 tribes, not only one or two. So many tribes, they have their own systems, customary laws they follow. You are saying something?
There is one criminal case instituted by members of Junta against another members of Junta. So there are two complications.
We'll come to that little later. I'm talking about trial of cases like murder cases. All right. Now, earlier in olden days, they used to decide in murder cases. Now, as I told you, Nagaland is a state which has so many communities, no? Tribes, 16 tribes at that time. Now also I think they are 16. They have their own system. One of our friends in the bar, we were just beginners in the bar. So he was from some community, some tribe in the interior area, from the interior area. He used to tell us, what happened was, one person was found stealing charcoal bag from one place, from another's house. Charcoal, I think, in those areas, and even now also they use this in the winters, when it is cold, they use charcoal. So this man had kept his charcoal in the outside his house probably. So in the night, what he saw was one person was stealing away, taking away that charcoal bag without telling him. So what he did, he just quietly went inside, brought out his gun and shot him dead. only for stealing a bag of charcoal. He was not even told why you are doing that. Just a shot. And then the community, tribe, whatever system they had, I think they had a meeting like Panchayat and settled the matter. Some fine was imposed, he paid it to the relatives, family of the person who was shot dead. But what happened after 6 months was, this man who had shot dead that person, thinking that he is dead, he was shot dead within 6 months. That settlement with compensation, all that was not effective. So in the olden system of administration justice, one method was, what is that? Eye for an eye, tooth for tooth. Eye for an eye, tooth for tooth. So when somebody has killed somebody, the next thing that can be compensated to the other person is by causing his death. Death for death. So that was at one stage, that system was prevalent in societies and in Jungsa also. In olden days, they used to decide murder cases also. So, but in the older system, before the system of this law and all that developed, the principle followed was eye for an eye, tooth for a tooth. So then only the matter was settled. Now, I am talking about an incident which is not very old. I think it was about not even 50 years. 60s, 70s incident. So 40 and 20, more than 50 years. It was there in tribal society in Nagaland. Now also it is there. They have their own system.
It's called Ho-Ho.
Yes?
It's called Ho-Ho. The Council of Elders is called Ho-Ho.
In Naga.
Council of Elders.
Council of Elders, I think.
It's called Ho-Ho.
Headman.
Ho-Ho.
Even in the district courts, we used to see, they would outside, they would come and sit, in a group. Some matters they would like to decide. not taking tea, but what is that called? Huh? Rice beer. With rice beer and all, they would sit and discuss the matter. Even in the district courts, they have that practice, that is there. So this is how justice used to be delivered in those times, and even in our state, that practice was there, but that practice is still prevalent in which part? That custom is still prevalent in North Sikkim. So this gives you an idea of how a practice develops, how it develops into law and all that. Now, next part that I would like to tell you is we have said custom ultimately develop into law, because legislation covers that area covered by the customs. Now here, what is the portion of Jumsa? All of you, I don't know whether you have ever known. Jumsa has been recognized and conferred the status of Gram Panchayat by the Sikkim Panchayat Amendment Act 1995. So Jumsa has been recognized as a Panchayat now. 95, without disturbing the powers and functions being either to exercise under the traditional and customary laws. So clear how a custom which was in practice for a long time has developed into law. Now that has become a Panchayat under this Panchayat Amendment Act 1995. So this is what I was telling you. There is no need to go to ancient time to find out how the custom developed into laws. In our own state, you have that living example. It is being done today. Now that has not been abolished. It has been recognized as Panchayat in the Panchayat Act. Now, without disturbing the powers and functions being either to exercise under the traditional and customary laws. So I am clear? Or not I am clear. The matter is clear? I am clear or not doesn't matter. The matter should be clear. Yes. So this gives you a clear picture of how a practice assumed, exercise, followed by a community for a very long time, develops into a law, legislation, law which is framed by legislature. So this is my purpose of taking you through this story, and it shows that the theory that a custom develops into law is not incorrect. It has a very living example. So, what is the next thing we have to do? Customary laws of Sikkim. Customary laws we have, and that has developed into laws in number of cases. Like that in marriage laws also, I think number of provisions contained there where the customs, practices adopted by the societies. Yes, your question? Something you were saying?
I already said.
You said, but have you dealt with that? You have got the answer to that?
I was telling that I'm presently also in charge of the Court of Judicial Magistrate Hon'ble.
Mangan, not Jumsa, you know very much that.
Yes, Lordship. So,
We'll ask you about customary practices also later.
I have not come across any customary practices, Lordship, but there are cases, criminal cases coming up from
From the north. You were saying something, somebody against Jumsa, what is that?
Members of Judicial have lodged criminal matters against other members.
Oh.
That is of cross.
No. Criminal matters in respect of what offence?
Lordship, I think an election was going on.
Yes.
Sir, I think Lordship, the election for the members of Jumsa was going on.
Yes.
So they were opposing parties. They fought with each other, and one party filed an FIR against another.
That is a different thing. That is purely a criminal, I think, issue.
Those kinds of cases that are coming,
No, we are talking about the decisions which the Jumsa arrives at after hearing the parties. Not issues relating to what offence they have committed. This fighting between the two is different thing. It is covered by Indian Penal Code. Don't mix it up with the Jumsa matter. Jumsa is separate.
Lordship, but what I've heard, I haven't personally witnessed it, but I have friends from the region where the Jumsa practice is prevalent. It's not actually amicably settling the matter, Lordship, like how
Yes.
the panchayat.
It is not amicably settled.
It's more like an imposition actually. Like for instance, if there are cases of bigamy and all that, Lordship, the person is made to pay a horrendous amount of fine and the amount that goes up to crores also. And this person has no say in anything. He has to make the payment, otherwise he'll be banished from the entire system. He's made to forego all his property and everything. So it's not actually amicably settling. That's what I've come to hear. It's more of a situation.
No, I think we are not talking about amicable settlement like in Lokayukta.
Yes.
Jumsa has an authority to decide matters even when the parties are at dispute. All right, one is saying one thing, the other is saying. There also they can issue, and as we said, the decision given by them is accepted. Now, supposing if somebody, like you said, does not accept the decision given, then naturally he has a way, I think.
No, Lordship. He is made to leave the exact case forego his property. Even if he's saying,
This is the customary
I'm
law.
not happy, I will not push the court.
This is the customary law.
If it is the title, property disputes also, and if they see.
Now it will be like this, whether it can go to that extent. Here we have said, the Jumsa hasn't conferred the status of Gram Panchayats. Gram Panchayats by the Sikkim Panchayat Amendment Act. Now, their power will be regulated by the provisions contained in Panchayat Act. If they go beyond it, that will be challengeable. Is it right? Correct? That is why it has come under the legislation. Anything, now they say, anything they do which comes in violation of that, then it will be regulated by that provision. You can advise the parties like that. If they come like that, this is the law, you can do it. Alright. Customary laws, so it is like that followed. I think I can tell you about one case which we decided in High Court Lokayukta. Oh no, it was High Court Lokayukta, quite long time back. In that case, the case was filed by one man. His allegations against the lady was no, it is the lady who had filed a case against the gentleman about more than 1 lakh something amount, claiming that he has taken this money and then I should get it. So we summoned the other party also, and when we discussed in the Lok Adalat, that case is there, record is there in the Lok Adalat also if you want to see. And what he said was, he said, I have not taken any money from her. there are many matters. If I have to say everything, then things will go to quite different extent. Always, that's what he said. Then the lady was also there. We told her, we have claimed that more than 1 lakh he owes, but he says he has not taken. What would you like to do? Then the lady said, all right, in that case, let him go to the Gumpa and swear before the deity that he has not taken money. If he does that, I will not claim. I will give up my claim. That's what she said. Then it is Lok Adalat. We don't have to stick to law provisions and all that. What we did was, okay, in that case, he agreed. The man also agreed. Okay, I'll go and swear. What is there? He was quite ready. So one of the legal officers, I think we employed him. He will go with the parties there, and whatever happens there in the Gumpa, he will report. So we gave them a date. Then the report which came on the next sitting was, this fellow, before the, what is that called, Murti? Before the deity, image, the deity, he swore before all of us that he has not taken any money from this deity. He said, I swear that I have not taken any money from this. Then he recorded that also. It was recorded, he said this, and then we had asked him to submit a report, whatever happens. So we went through that, and then we told the lady, you had said that if he swears it before the Gumpa deity that he has not taken money, then you will give up. She said, well, all right. If he swears that, I will not claim. And the matter was settled. Customary law. That was the customary law. In Lok Adalat, we followed one customary law. So, if somebody goes, I think many disputes are decided by swearing also. It is in the 16 laws also. One has to go, swear before the God, and then say what is the correct question, and then that will be taken into account and decided. So this custom, even to this day, in some areas, not in district court, you cannot do that. But in Lok Adalat, we did that. It is just 4 or 5 years. Or maybe it was before I laid down office. It may be 8, 9. There's a record in the I don't remember the name of the parties, but there's a record. We have recorded everything there. This was the claim, this he said, and then we sent so and so, this party is to the Gumpa, in the Gumpa, as per the report submitted by so and so. He swore before the deity that he has not taken any money from the lady, and when the lady was asked as to what she has to say after the gentleman swore in, then she said, well, he has done the swearing before the image of God, I have nothing to say. So this was settled. So easily, so nicely it is settled. Look, customary law. So these laws are there even as of now, customary laws. So this is what the customary law which is prevalent in our state, and in some cases which has taken the shape of law also, which are embodied in law also. So, any question? This decision which Lok Adalat gave is not challengeable. Don't think of taking it to High Court. Lok Adalat did this, because he followed customary law. It is not like that. They have agreed. Customary law says, if you go and swear before in the name of God in a gompa, and then all right, I'll accept. I think something different from material objective is there. No? After all, God is there. This is, I think, the concept. Ultimately, God will decide, not the Lokadarat. So, what is the present position of customary laws? Let me say, in primitive society, as you have said, custom was the sole source of law. There was no king, no state, only society. However, with the passage of time, importance of custom began to decline. Why those who have been included, embodied in the legislation, that in that case, that custom cannot follow. Then another is judgments of the courts began to cover skills previously occupied by custom. Courts also. And I think there are justifications as per custom they have done it. There are some Supreme Court judgments also. If time permits, we'll come to that. Then legislature began to pass laws dealing with subjects previously covered by custom. Like that, those laws, registration of marriage and rules, Special Marriage Act. So legislature began to pass laws dealing with subjects previously covered by custom, and thus most of the customs have become part of the law of the land. And I have already given you an example of Jumsa, which has customary law, but it has become part of the state-made law, Panchayat Act. No, but as I told you, it will be regulated by the provisions of the Panchayat Act, not by the earlier customs. Consequently, custom as a source of law has lost its former position and importance. So custom is to be, I think, in that meaning we have to understand. Present position is like that. That importance which it had before system of monarchy came, before the concept of state came, at that time it was different. But now, after the coming into existence of the institutions like monarchy or democracy and all that, now customary laws have lost their importance, value and importance. Customary laws, there is one phrase I got it from one book about customary laws. It is about Punjab. It says, customary law as it applied to Hindus in Punjab, talking about it applies to others also, in Punjab, has ceased to exist with respect to any matter for which provision has been made in the Hindu Marriage Act. This is what I was telling you. A provision has been made in the legislation that has been brought afterwards, after the institution of Parliament and assemblies came, says customary law as it applied to Hindus has ceased to exist with respect to any matter for which provision has been made in the Hindu Marriage Act. Now what is there in the Hindu Marriage Act? You will have to follow it. If it falls, it's outside, then only. Hindu Marriage Act, the Hindu Succession Act, the Hindu Adoption and Maintenance Act, and the Hindu Minority and Guardianship Act. So this is the position with custom. In Hindu Marriage Act, in that Special Marriage Act, a number of areas earlier covered by customary laws have been covered by these legislations. So in the situation, what can be concluded is that the law as contained in the customs have been repealed, not formally repealed, but in practice. that we have already done. Now, about this, you have anything, any queries to make? Anything in your mind? Any one of you? If you have anything, we can discuss. Otherwise, now the topic is marriage with reference to marriage of tribal communities. I was given this draft on customary laws of usage of Bhutia community. This has been done by Law Department.
Lordship,
All-
that's why I wanted to say, Lordship, Law Department under the Law Commission.
Law Commission.
All the communities where but customary law, the books
Ah.
have been compiled, but it has not been codified. Lordship. It can be codified. Lordship.
No, customary law, how can they codify it? No, only it can be compiled.
It is already compiled. Lordship. It is here.
Ah.
It has not been notified.
No, but why should it? How can it be notified when it is a custom? Then if you notify, then it becomes a legislation. It becomes a law. Like that, the rules of registration, it has become law. It has been promulgated by the state. But if it is to remain as custom, it cannot take the form of legislation. So this is no. This is compiled. You can compile and keep it as a customary law, and if it is found that this is not covered by the provision of the laws which have been passed by legislature, in that case, in those areas, it will be law.
What should the Hindu law, what is not customary law before it was codified?
Yes,
Hindu law, what is not a customary law before it was codified into
that's what we are saying. Customary laws were there about ceremonies and all that. Now, Hindu Marriage Act has covered all those.
It has now been codified.
Yes, that's what I have said that about Punjab. Those laws, those matters will not apply in those cases, in those areas which is covered by Hindu Marriage Act, Succession Act and all that. It has become legislation. Now, to make the customary laws, I don't think that is the correct way. Customary law, if you have to say that it remains a custom, it cannot become a legislation by the legislative authority of the state. So it has to, you have to leave it as a custom. Then just compile it, this was a custom. But so much of it is covered by legislation now, this will not apply. But in these areas, it can apply.
Can we rely on this?
Yes?
Can we rely this to compilation?
No, in this compilation, there are details have been given. In those areas, if you find that those areas have been covered by legislation, out of question.
There is a provision for divorce also. Divorce, adoption, marriage also.
Yes,
In customary law.
yes.
Then,
Now among the Hindus, it is governed by Hindu Marriage Act. Conditions have been laid down.
so far as tribal is concerned.
Yes.
Tribal is concerned.
So far as tribal is concerned, you are reading that Article 2, what was that, in what act you have read? In what act you have read that? Hindu Marriage Act? Section 2 says it do not apply to? Apply to scheduled tribes.
Then you have a
So if it doesn't apply to scheduled tribes, it cannot override the customary practice provisions. Because it doesn't apply.
It is codified also.
Huh?
So far as tribal.
No, codification, so when it is codified, it will have to be made a law, you will have to, these notifications and all that which government has issued, that can be codified. But customary laws, you can only, a narrative of that, what is it? So it could be rather Hindu Marriage Act, a codification of the Hindu customs of marriage.
Can you not, can the same will apply in this case also?
In which case?
This one, the same,
Huh?
customary law.
Customary, all the customary law, all communities are.
Yes.
There are both also.
No, I couldn't get the question. Tell me.
Worship, the question that I understand is, these laws, the customs, have now been compiled of various communities of Sikkim by the law department.
This is by law commission and law department also, I think.
Yes. And the question
Law
is,
commission, law commission of Sikkim is this one.
the,
Law department.
the question is, can the courts rely on these documents whenever there is a question, let's say for...
No, question of, I say you can rely, the implication will be that you are bringing that into force. You are enforcing it against, how can you enforce that, which is already covered by legislation?
No. Let's say, for example, the question that is raised is, the husband and wife are tribals. They don't fall under the
Intermarriage
Act. So they want a divorce. The problem right now the courts are having in Sikkim is that Hindu Marriage Act is not applicable at all. And in order to prove divorce under the customary law of Sikkim, the question is, can we rely on these documents?
Rely on?
On these compilations?
No, compilation you can read for always. Because, as you said, tribal, now in this compilation, say, I was reading, going through some of them, they say they have a provision for divorce. Among Limbus, there is provision for divorce. Among Bhutias,
Yes.
there is a provision for divorce.
But the question
And then you will have to, you can follow that.
But to prove a customary law under the Evidence Act, we'll have to bring proof.
You will have to examine, that's what, why we read that. You will have to examine the people, old people, elderly people who have the idea of the custom and practice being followed.
So if we bring those people, then this becomes unnecessary.
Which becomes unnecessary?
The compilation, because they would repeat the same compilation.
Compilation is only a rather a record of what is. Compilation is not a law which is brought by legislation by this legislature. Compilation is not a legislation. So why? How can you treat it as a law?
No, the point my colleague here was trying to make is not codified, but if this compilation is notified that this is the customary law of Sikkim,
then whenever the question of customary law arises, alright?
then we can.
Whenever the question of customary law arises and say some issue like whether in that community, in the tribal community, Limbu, Tamang or Bhutia, they had a practice of divorce. In that case, you can cite that, yes, they have a provision. Because it has been compiled after examining so many old people.
Different places.
It is not just a narrative given by the law department, but it is something which has been compiled on the basis of statements given by
Different people from
different people. There is of course some difference here and there,
Yes.
but then you have to finalize which is correct.
So our request was,
Yes.
if this is notified, then we don't need to examine other issues, but we can
No.
directly go
To
ahead.
the extent that there was a
There is a practice, yes.
practice of, to the extent that there was a practice of divorce, that would be sufficient, because that is a custom.
Because right now it is only compilation, like any magazine.
No, compilation is for the purpose of referring it. Now in the evidence that we were reading, if there is some entry in some register and that will be relevant, this will be a relevant issue. You can say this part you can consider, and other facts also you will have to consider. Compilation is not a legislation. Compilation is only a collection of what? Collection of the practices which has been brought into writing, which has been recorded into writing, and that you are citing. Then here, if the question whether there was a practice of divorce in Bhutia community, you can cite this. Who is from Bhutia? You are from the Bhutia community. This is Metta community. This is Bhutia. Their community. Now marriage. This is marriage. See, if a question arises in a matter between two tribal communities here, the question is whether the community had the practice of and the custom of divorce, then here we have said, is divorce permissible as per law? Bhutia community. As per law, is there any customary divorce? Divorce is permissible. This you can certainly cite, but not as law. As a proof of the fact that there was a practice of divorce in the Bhutia community to that extent. You can't treat it as a law.
One interesting question is...
1 minute, who is asking?
Yes.
Oh, you are asking?
Yes. Right now the problem is whenever there is a divorce between the tribal communities. Now within the tribal communities also there are different tribes. For example, there is, and we have seen inter-caste marriages. Let's say the wife is from one tribal community and the husband is from another tribal community. So if they want to get divorced, which law, customary law will prevail?
Your law covers that, it's some issues. Huh?
Yes, different.
Different, yes, it is there, you have to see this.
Different community.
Yes.
There's a different scope of...
Yes, it is there.
If it is lecture, they are getting married.
Yes. You have read this?
I've read the Bhutia communities, Darshan.
This is Bhutia communities. This is adoption, that is will, and then minority in that. History of Bhutias. Then history of Sikkim. I was going through. There are practices. There are provisions which covers cases where both parties are different from different communities. Somebody doesn't want legislation that should not come in the way of, I think, power of the authority to make legislations. During King's time, King was the monarch, King was the magistrate, high priest, all in one. So whatever he does, whatever he says is law. Now there a member of the community cannot say, I don't want to accept what you have said. He cannot say it to the laws made by the king. And similarly, now, what is the present dispute going on about? It is about Waqf Act, amendment of Waqf Act. Muslim ko hai na there? There also the protest is going on. So the essence of the matter is, it is not that what a government does will be acceptable to all the citizens. It's not like that. There are people, there are areas who have different ideas, who have different intentions, but the fact that they have not agreed to this doesn't mean that affects the power of legislation. So, what is it? It was said in that Supreme Court judgment on 3, that was, I think, in some states. He is the supreme legislature, he is the supreme executive, he is the supreme head. So, all in those cases he is supreme. So, what has been done by Supreme, whatever act the Supreme has done, Supreme authority has done, Supreme sovereignty has done, no citizens, copies, no, they can certainly come and say we don't agree, this should not be done, but then unless that becomes a view of the majority. It cannot be accepted by the legislature. Let us see in that work case. It's going on now also. So many enactments, many amendments in the constitution also it is like that. So the fact that few of them are objecting to it, are raising some objection, they are protesting, doesn't mean that the authority exercised by the sovereign authority is to be ignored. It is not like that. Here the question of supremacy comes. One who raises objection has no supremacy. He has no authority to even challenge it. That is the concept. But then there are some judgments, of course. What is the time left? Huh?
That is not much.
Oh, what is this? Huh? Everybody is keeping so quiet and silent when the time is over. So briefly, all these I thought will go to different customaries of these tribals, no? But then time is, I think, not sufficient, looks like. But all just a few sentences. You can hear, I suppose, even when time is over. It's like this. Some issues like this had been raised, in Supreme Court. Article 341 is about Sikkim. No, 371 is about Sikkim. Article 372 is about? 372 is about continuance of law of then British India. Three 371F is Sikkim. 372. Please read. What does it say? 74. 71F. 371. 372. Did you get it? Read it. Continuance in force of existing laws and their adaptation. Existing laws means laws in existence in force in India at that time. And in 371 Act we talk about continuation force of laws in force in Sikkim. There are some decisions whether these customary laws that we are talking about, whether they fall within the meaning of laws in force in Sikkim. Have you any idea whether do they fall? There are some judgments also, some decisions and some which say that the laws, customs and laws, if they are in force at the time of appointed day, they will be covered within the meaning of law in force. Alright? So we are saying whatever now the question raised by one of you had raised that whether protest when is raised, what is the position? As I told you, when it is a legislation brought about by the supreme authority, by the sovereign power, then the fact that some have objection will make no difference. There will be no difference. But of course, if this majority, then they can again think about it. Like Muslim Waqf amendment method is in dispute now.
Yes.
So it's like that. So what I was going to tell you, I've spoken more sentences than few, as I told you. Some issues arose in this 372 issues, no? Whether the laws in existence which are framed by those days who were there. Nawab of Hyderabad and what Nawab and what were they called? Nizam and all that, made by them, whether they can continue, they have been said, where they are covered by the laws in force at the time of enforcement of the Constitution. So a number of decisions given by the Supreme Court in the beginning days, they said, as I said, the lawmaking, the Nizam is the supreme power, is the supreme legislature, supreme executive, no? So whatever they have said, whatever orders they have passed are laws and they will have to be followed. They will follow that. But however, that decision was later on reviewed by the Supreme Court in other decisions. There's no time I have given you those citations. So in those decisions, Supreme Court said that what Supreme Court said was, with the Supreme Court, when it said that whatever they say, it should be a law, it doesn't mean that it means all the orders passed by them, whether legislative or otherwise. So what was said was, whether the order passed is has the jurisprudentially legislative implication it should have. Only those orders which have jurisprudentially legislative nature, they can only fall within the definition of law enforced. So that amendment. So when the judgments are applied to our case in Sikkim, then also those orders, all these notifications, if they are within if they follow the definition of jurisprudentially legislative process, then they will have the force of law and they will have to be followed. They are covered by 371 F-K, law enforced. So you will have to show, what does it say? Law enforced at the time of 371 F-K. 371. Few minutes more will be, not much.
The request is coming from the side.
Yeah?
Loss of the 3 minutes, yes.
Just 371 F-K. K. All laws in force, this will come into issues in number of cases. All laws in force immediately before the appointed day. Appointed day in the territories comprising the state of Sikkim or any part thereof shall continue to be enforced therein until amended or repealed by the competent authority. This means all this, we talked about customary laws and all that also in orders. If they fall within the definition of jurisprudentially legislative process, then they will be treated as laws covered by 371 F-K. But if this is not, then they will not fall. So that's why even customs will fall under that. So this is something which should bear in mind because we have still long years to go. You can face many questions like this. So if you have these concepts in your mind, then it will be, I think, easy for you to deal with the matter and give a decision which is right, not wrong. So this is all. No? We'll conclude here. Thank you all for